speaker is Dr. Yael Berda, who is an assistant professor at the Department of Sociology and Anthropology at Tel Aviv University, and an academy scholar at the Harvard Academy for International and Regional Studies at Weatherhead Center for International Affairs, Harvard University. She received her PhD from Princeton University, MA from Tel Aviv University, and LLB from the Hebrew University Faculty of Law. Berda was practicing human rights lawyer, presenting in military, district, and Supreme Courts in Israel. Her first book, The Bureaucracy of the Occupation, published in 2012, explored the administrative aspects of the Israeli occupation of the occupied territories. Her second book, Living Emergency, The Permit Regime at the West Bank, is forthcoming in October 2017 by Stanford University Press. She is currently working on a manuscript titled Between File and Checkpoint, Citizenship and the Administrative Memory of the British Empire, on the bureaucratic legacies of the British Empire in Israel, Cyprus, and India. Berda writes about the intersection of law, race, and organizations. She teaches sociology of law, state bureaucracies, sociology of empires, and societies in Israel. Her lecture is titled The Ethical and the Political is Either Details. Thank you.
Thanks. Thanks for inviting me. I'm not part of the Safra Center, and haven't been, and so we each have different relationships here with the center. So I'm an outlier here, and so I want to talk about locating ethics in law and administration. And when we talk about science and ethics, there seems to be an intuitive clarity about this. Of course, people who don't research the topic have an intuitive clarity about this, about the distinction between the two and how ethics and science are distinct from science itself. Whereas in law, the boundaries are blurry, and the location in ethics in the law is discipline, law is practice, and law is profession, would be in dispute. Bruno Latour, in his ethnography of the French High Administrative Court, the Conseil d'État, compares scientific objects and legal facts, seeking the similarities between epistemology and justice in the daily practices, spatial rituals, and routines of power in what he calls this laboratory of law. This morning, as I attempt to locate ethics in the law, I will compare the practices of procedure in law and administration, which we tend to think of as the Janus-faced boundaries of the state. Latour, in comparing the court to the laboratory, writes that conseils, and I quote, remain within the world of text, end quote, those that are in the file, whereas laboratory researchers are forever crossing the deep chasm that separates a rat's neuron pulsating under a micropipette, I don't even know how to say this, pipette from the human phrases spoken in relation to that neuron. He also finds, end quote, he also finds that it's the nature of the file and its closure, as opposed to the messiness of the laboratory work, that distinguishes law from science. So I would like to challenge Latour's portrayal of the legal discourse as one that remains in the world of text, and to question that closure that ends within the file. So against Latour, I pitch, I'm going to pitch legal theorist Christopher Tomlins, who proposes a focus on intersections between legal thought and technologies, artifacts, and material practices, how law is expressed as a technology and artifact, and how law is a differentiated category of action. And so, following Walter Benjamin, Tomlin suggests, and I quote, we must recognize that the law or legal thought is not enlivened by the relationalities within which it allegedly belongs, the relationalities of its time, historically, but by the fold of times that creates it in constellation with the present, the moment of recognition. So I basically think the anchor of the moment of recognition is simply called procedure. So I'm going to argue that that when we focus on the differences between procedure, which are a set of actions, boundaries, and performances, where I'm going to argue that ethics are located and reflected in the dynamic relationship we call law, and the content of the case, which is engaged in the text in the file. So I'm willing to go with Latour that says the conseillers are speaking about the text when he's talking about the content, and that the file, when it is closed, it closes the content. But when we talk about procedure, it's a whole other game, and that's the game where the texts are in relation to actions and discretion and decision. So the protection of citizens from expert knowledge takes place in the law through procedure and its technical boundaries, especially in the rules of evidence. And although procedure is an asymmetric set of actions in which corporations and states have greater power than subjects at all times, the courts take very seriously procedure and technicalities as constraints on discretion, part of the performance of fairness and justice. So this performance of fairness in the procedure is significant as a location of ethics, and I hope to convince you of this in the next few minutes. So very different. So I am calling it the performance. Ethics are in the procedure. Courts are very much into performing performing this set of ethics. All right. So very different from the legal procedure in courts. In bureaucratic administration of the state, similar procedures are simply weapons of the experts. I'll be referring to, basically, I'm going to be referring to British common law and British administrative legacies, which is my main interest. Some would say an obsession too. But also, because when we're talking locally, here in Israel-Palestine, we still have a constitutive relationship with the British Empire via its legacies. And so when we speak about procedure, we're speaking about the procedures that are legacies of the British Empire. I argue that currently, ethics as well as the defense of rights takes place mostly and perhaps only through procedure. And the technicalities and their stability are the last defense, even though most of the time they are used against the weak. But procedure is still the last bastion for oppressed communities. In the procedures, the legal system paints its self-portrait, inscribing its regime of justification as a legitimate guard of the spirit of liberal democracy. So we see this especially in the places where these regimes of justification fail. For instance, like in the military courts of Judea and Samaria, there's more and more examples. But when the performance fails, we can see the stark difference between where the performance is taking place, the performance of procedure, justice, fairness, due process, all that, versus the places where anyone walking in would say, aha, there is no due process. So that's what I mean by that. So on the other end, procedure and its administration, it serves directly for the weapon of oppression because of the growing power of discretion within procedure, particularly procedures of classification and categorization that determines a person's status and with it their rights. So I'm briefly going to speak about two cases, the legal procedure for introducing secret evidence in courts and the administrative process of determining political membership. So determining whether one is a citizen, resident, asylum seeker, intruder, all those. So how do we locate the ethics of the technicians of law, administrators and judges? So basically, the procedure-substance dichotomy is usually attributed to Jeremy Bentham. And in courts, the decision whether a rule is one of procedure or one of substance usually arises when there is a conflict of law. So deciding whether a rule is of procedure or of content comes up when there is a crisis. So British courts extended the meaning of the term procedure very broadly, a maneuver that was being critiqued because of a growing concern that procedure was taking over substance. And against this grain of broadening procedure, a new movement arose that I'm going to talk about later. So, I want to focus back on the basics. So, criminal procedure is predicated on notions of fairness, as the imaginary game of adversarial courts demanded rules that would correct the asymmetry in power between the state and the defendant. So I'm not going to dwell on the imaginary of fairness, but I also wish to acknowledge that fairness and expertise do not meet. So in the sense, fairness and due process are the pillars of liberal thinking on democracy, so basically the equality before the law. That's not the way we think about procedure in administration, which is the realm of experts. So we have the separation between fair play and expertise. But when we look back at the foundation of Max Weber's model of rational legal bureaucracy, we can see both the professional ethics of the bureaucrats and the attempt of fairness through two principles, impersonality and universality, both stemming from the Roman concept of sin aera et studio, without scorn and bias. And so this is underlying the administrators as well. So very similar to fair play and due process. So originally, procedure and common law and rational legal bureaucracy harbored ethics within the procedure. So when and how do ethics separate from procedure and administration? Similar to Latour's reference about the way law lives only in the text, many scholars have taken for granted the centrality of documents and the way documents constitute, create, and make the law. And so the study of documents and their centrality in state bureaucracy is much more recent, and it hinges on the materiality turn in anthropology and history. In many ways, is a derivative of science and technology studies under the influence of the Latourian methodology. So it's actually looking in through the Latourian lens that led people to ask questions about procedures and bureaucracy, and especially documents and their creation of procedure. So the centrality of paper and documents to the construction of bureaucracy and the studies of documents, technical infrastructures, and law and administration have contributed also to the study of organizations, as processes of documentation gain prominence in the age of information. And some of the people that are doing this are Matt Hall, historian Bhavani Raman, political scientist Lali Khalili, and probably most known to the legal community, legal scholar Annalise Riles. So tracing the legacies of bureaucratic practices means not only taking into account their specific historical context in which they were produced, used, diffused, and adapted, but also taking into account the role these practices and artifacts play in different junctures from the contemporary vantage point of their effects, mainly their procedural effects, because the document is there when there is procedure. It must be there when there is procedure. That's why documents are of interest to us. If we follow the lead of Annalise Riles that suggested scholars take on the technicalities, this is back in 2005, and we focus on administrative technologies rather than focusing on the content of bureaucratic correspondence or of the substance of the legal dispute, we can reveal both how legal adaptation works and we locate the actual place where ethical and political debates take place in the law and in administrative practice. But first we must turn to look to the power of the administrative form. Legal theorist Cornelia Wiesmann shows how, over time, administrative files have enabled governments to detach administration, the nitty-gritty of legal life, from abstract laws through administrative acts of transmitting, storing, canceling, manipulating, and destroying the history of the law. End quote. So technical adaptation of legal form is not just a procedure. The procedures themselves encompass legal and political ideologies, legitimate the role of lawyers and administrators as technicians of law, and reflect the organizational structures that bind them. In the last decade, anthropologists have turned to political and relational genealogies of documentary practices. And so they address the way in which the aesthetics, form, and materiality of documentary work shape the ways the performance of documentary practices themselves enable particular subject formations, modes of governmentality, new and ongoing expressions of sovereignty and agency, and the circulation of affect. So administrative tools are the administrative forms are the tools that enable an administration to collect and register information in a systematic way. So now I'm talking about the weapons part. Forms are universal. They standardize the mayhem of the real world into a set of simple, legible answers. They guide and limit the way in which humans go about their work. And indeed, they define themselves in relation to the state in writing. So when we take on the technicalities, we have the opportunity to witness the trajectories of law and practice, how they turn from legal procedure, where ethics are located, into the administrative action, which is exactly where Latour is telling us that the scientist who hold the rat, the scientist that holds the rat, is then speaking about the rat. So this is exactly the moment when you're turning from the legal procedure into administrative action. So the same thing is happening. It's definitely not happening in the file with its closure. So back to the administrative procedure as a weapon. Material forms of documentation that anthropologist Matt Hull calls graphic artifacts create a government of paper. The official form in which a single box is checked demands a choice determined by a person assuming a collective administrative identity. It can be a state, a corporation, it doesn't matter. These categories are entrenched in the structure of the institutions themselves. And so then official categories influence change in everyday politics and routines that then demand new classification. So from an institutional perspective, categories accumulate next to procedures. Categories and procedures accumulate. On the basis of group categorizations, rights are granted or denied, determining political and social status of individuals, while impacting their daily lives by means of facilitation or denial of the right to entry or exit from the state, property rights, rights of marriage and family unification, and access to public services. Categories, for instance, today, I don't know, I think we're into the 40th or something days of the Palestinian prisoners' strike, and one of the things that they're striking about is being categorized as... It ended?
Yeah.
When?
Yesterday.
I didn't know.
Yeah.
I didn't know. Just goes to show you. So the strike after 40 some days. So part of that strike was exactly about being classified as a security prisoner versus other classifications. So it's literally going against the procedure of classification. So this has really serious, big effects on daily life. So these categories, particularly the processes of exclusion of individuals from political membership, necessitate the creation of administrative technologies to coordinate between the bundle of rights granted by political membership and the documents and evidentiary demands to match it. They also mark the territory the person of a certain category can legally inhabit as citizen, resident, guest, or intruder. The law constitutes an actual boundary for movement within a particular space via the procedure. The administrative file that holds the evidence for a person's belonging to a category creates a triangle, providing a link between the law, spatial boundaries where one can reside for a limited or unlimited amount of time, and the person herself. So if the Roman proverb states the administrative file opens up a world, the administrative file of a person classified as a refugee or an intruder is a map depicting the space where she no longer belongs. So finally, I'd like to talk a little bit about secret evidence. So secret evidence is the process of bureaucratization of discretion, where administration erases the procedural elements of the law that protect rights. So very briefly how secret evidence works, and I'm going to speak about the High Court of Justice, Bagatz, because the criminal procedure is more elaborate. So when there's submission, usually by the state, only by the state, you can't, you could never submit secret evidence if you're not the state. It just dawned on me. Yeah. So when there's submission of secret evidence, the defendant or petitioner and her lawyer both leave the courtroom while the secret evidence is presented to the state with the state attorney. They show the court the evidence or even a paraphrase of the evidence. So it's not necessarily evidence itself. It's a performance of secret evidence. And so there's complete destruction of the adversarial facade of fairness and due process. No open cards, the cards are hidden, no full asymmetry, justified asymmetry, definitely. And very similarly it's very similar to the administrative process, where you don't need to declare the need for secret evidence because most discretionary decisions do not disclose the range of evidence, and many times they don't even need to provide the reason. So in many ways, the bureaucratic procedures are like the court procedure where secret evidence is introduced. And that's the easiest way to understand it. So this moment where everybody's like, whoa, what's happening? You know, you're destroying our whole facade of due process, is exactly the daily life, bread and butter of the bureaucratic procedure. So legal philosophers are writing now of a growing trend to obscure the sharp distinction between substance and procedure, greater flexibility of procedural norms and growing judicial discretion to deviate from procedural rules. Two young local legal philosophers, Ronit Levin-Schnorr and Ofer Malkai, claim that these transitions from rigid procedure to fluidity and flexibility reflect a change in the moral framework that traditionally viewed the necessity that legal decisions be made under strict and rigid procedural constraints. They've investigated this contemporary change and call our attention to trends towards flexibility in procedural constraints and thresholds, such as the admissibility of illegally obtained evidence and dents in the reasonable doubt standard of proof. And so here, almost 25 years ago, Professor Meni Mautner wrote of the decline of formalism and the ascent of values in Israeli law. And to many, this was a very mechonen, how do you say? It's like a constitutive text in your legal education as a progressive Israeli scholar, right? And so a year later, sociologist Ronen Shamir wrote of the politics of reasonableness and how a new managerial ideology of court discretion, guided by liberal principles, were eclipsing the rules of procedure. And he warned that it would exclude certain populations from the purview of the court. So indeed, many celebrated, many, even around this table, perhaps me as well, but I won't tell you. Many celebrated Mautner's book on the decline of formalism as professing a progressive new era, while Ronen Shamir's warning loomed silently against guiding discretion by principles rather than keeping to certain structures and procedural constraints. So the rules of procedure were consistently critiqued by cause lawyers and scholars of race and inequality that pointed to the ways that racial class hierarchies are inscribed into procedural rules and organizational practices. Lauren Edelman, David Cole, Frank Dobb, and many others. So one result of this critique was the gradual erosion of the oppressive procedures in order to benefit oppressed populations through the use of discretion based on context and content, especially the principles of human rights. So in turn, as context took precedent over procedure for the sake of promotion of human rights and democracy, this process eroded this last bastion of constraint, whether real or imagined, where ethics were quarantined into the semblance of fair play and due process. So why is the erosion of the oppressive procedures so dire for the disempowered? Because the shift between procedure and substance can never be used only for the benefit of the oppressed players via general principles of rights. The privileged aggressively use the new freedom from procedure, the progressive shift away from the dinosaur-like constraints, where ethics were huddled not only in the courts, but in legislation at all levels, perhaps even in bureaucracy. So through this new flexibility of procedure, law and administration became almost indistinguishable, shadowed by that shiny, bright code word that people love in this faculty, regulation, that replaces democratic deliberation, or at least the facade of due process.